Case 01, Otis Boone, March 2012. Kings County Supreme Court, Brooklyn, New York. The officer running the lineup gave Otis Boone a simple instruction. Step forward and say, "What time is it?" That was the procedure. Not a photograph, not a description match, not a DNA comparison, a performance. Police required a 19-year-old to recreate, in a controlled room, the exact words the actual robber had used, and then ask two white victims to confirm whether the voice and the face belonged to the same person who had attacked them from behind in the dark. They said yes. That confirmation, that scripted, staged, cross-racial identification, would cost Otis Boone 7 years of his life. Boone had arrived in New York City just 4 days before the first robbery occurred. He was 19, working casual jobs, living in Flatbush, Brooklyn, with family. No criminal record. No gang affiliations. His electronic benefits card records, government issued, date stamped, location specific, placed him approximately 1 mile away from the scene of the second crime, making a transaction roughly 5 minutes before it was committed. The NYPD had access to those records. They chose not to investigate them. The investigation was already complete in their minds. 2 white victims had pointed at a young black man, and that was considered sufficient. The crimes occurred in February 2011. On February 16th, a white man in his mid-20s was walking in Flatbush when a stranger approached from behind, asked the time, and snatched his phone when he looked down. The robber pulled a knife when the victim gave chase, then fled on foot. 10 days later, a white teenager was texting in the same neighborhood when the same approach came from behind. The same question, the same sequence. The victim resisted, and the robber stabbed him before taking the phone and running. Both victims described a black man wearing a winter coat and a hat with flaps that covered his ears and the top of his head. Boone was 19, 6 feet tall, and short-haired. No knife was ever recovered. No stolen phone was ever recovered. No DNA evidence was ever submitted. No corroborating physical evidence of any kind connected him to either crime. Police placed Boone in a live lineup and designed the procedure around the crime itself. They required him to step forward and say, "What time is it?" The perpetrator's exact phrase, delivered in exact sequence, directly in front of the men who had been robbed. The 2 victims, identifying cross-racially under the formal pressure of a law enforcement procedure, selected Boone. Before trial, the defense asked Judge Vincent Del Giudice to instruct the jury on the cross-race effect, the well-documented, near-universally accepted scientific finding that people have substantially greater difficulty accurately identifying members of a different race than their own. The research was not in dispute. Judge Del Giudice refused the instruction. His stated reason: the defense had not hired a private psychologist to present expert testimony on the subject. The instruction was simply denied. Trial began in July 2012 at Kings County Supreme Court. The prosecution's case consisted of the 2 victims sitting in a courtroom and pointing at Boone. No physical evidence of any kind. The jury heard nothing about the cross-race effect, nothing about the EBT card records, and nothing about the well-established limitations of cross-racial identification conducted under stress at night, with a weapon present, and from behind. The verdict was guilty on all counts. Judge Del Giudice sentenced Boone to 25 years in state prison. Boone shouted his innocence from the defense table. His family collapsed in the hallway outside. The case reached the New York Court of Appeals, and on December 14th, 2017, Justice Eugene Fahey authored a ruling that changed New York criminal law. In People v. Boone, the court held that in any criminal case where the identifying witness and the defendant appeared to be of different races, Defendants are entitled, upon request, to a jury instruction on the cross-race effect. No expert testimony required as a precondition. The science had achieved near consensus in the community of cognitive and social psychologists. The instruction was now mandatory. The decision became known statewide as the Boone Rule. The Boone Rule did not emerge in a legal vacuum. By the time the Court of Appeals issued its December 2017 decision, researchers in cognitive psychology had spent decades documenting the cross-race effect across hundreds of controlled studies. Courts in New Jersey and other states had already moved toward expanded eyewitness reliability instructions. Justice Fahey's majority opinion cited this body of research explicitly and noted near consensus in the scientific community. What made the ruling distinctive was its categorical holding. The instruction could not be denied simply because the defense lacked funds to retain an expert. That financial barrier, the one that had sent Boone to prison in the first place, was the specific obstacle the ruling dismantled. A retrial was ordered. In February 2019, Boone faced the same two witnesses again in the same courthouse. For the first time in any proceeding, the defense introduced the electronic benefits card records. Two transactions, approximately 1 mile from the second robbery, approximately 5 minutes before it occurred. The same evidence that had existed since the night of the crime. The NYPD had never examined it. Both victims again identified Boone in open court. The jury acquitted him on March 1st, 2019. The original judge refused to warn 12 jurors about a scientific phenomenon that is now mandatory knowledge in every New York courtroom. Not because the science was disputed, but because a 19-year-old from Flatbush could not afford a private expert to explain it. 7 years lost. Case 02. Ronald Cotton, Burlington, North Carolina. 3 days after the assault, Jennifer Thompson sat across a table from a detective and studied 6 photographs. She was 22 years old and had spent 3 days trying to preserve every detail of her attacker's face, actively, deliberately, the way she later described it, as an act of resistance during the assault itself. She had concentrated on his features, cataloging them as a survival strategy. Now she studied the photos for 5 minutes, narrowed the field to 2, and then made a choice. She pointed to Ronald Cotton. "I think this is the guy." The detective pressed her. She upgraded the statement. "It's him." The police officers in the room reportedly applauded her selection. That moment, the studied choice, the gentle pressure, the applause, was the beginning of a 10-year wrongful imprisonment and the global demonstration of how human memory destroys itself through repetition. Ronald Cotton was 22, a restaurant worker from Burlington with minor non-violent infractions on his record and no history of violence. He lived and worked in the same part of town as Jennifer Thompson. That proximity made him plausible to investigators. He was arrested in August 1984, charged with rape and burglary, and maintained from the first moment that he had not committed the crime. Cotton had a solid alibi supported by witnesses, including people who had seen him at a party during part of the relevant time period. The assault had occurred on July 29, 1984, at approximately 2:30 in the morning. A man broke through the rear door of Thompson's apartment, held a knife to her throat, and raped her. She escaped to a neighbor's home and called 911. The same perpetrator left her apartment and forced his way into Elizabeth Watson's apartment the same night, committing a second assault. Both women survived. Rape kits were collected from both. The true perpetrator was Bobby Poole, a man already committing identical crimes in Burlington, whose blood type matched biological evidence recovered from Watson's apartment. The defense would attempt to present Poole at Cotton's second trial as an alternate suspect. The judge would not allow it. Both Thompson and Watson were shown Poole outside the jury's presence. Both said they had never seen him before. Thompson's identification process demonstrated, with clinical precision, how eyewitness memory corrupts itself. Each identification of Cotton, in the photo array, then in a physical lineup 11 days after the assault, then at the first trial, then again at the second, reinforced the previous one. Memory is not a recording. It is a reconstruction, and every reconstruction incorporates the last version. By the time Cotton's second trial began in November 1987, Thompson's brain had replaced Bobby Poole's face with Ronald Cotton's entirely. She was not lying. She was not performing. She looked at the man who had raped her and was neurologically incapable of identifying anyone else. Judge Anthony Brannon denied the defense motion to present Poole as an alternate suspect. The jury convicted Cotton of both rapes and 2 counts of burglary. Judge Marsh McClelland sentenced him to life in prison plus 54 years. Cotton had been telling anyone who would listen about Bobby Poole for years. In prison, he encountered Poole directly, and fellow inmates reported hearing Poole brag about the Burlington rapes. Cotton's attorneys used this to secure a new trial. But Thompson again identified Cotton with absolute certainty at that second proceeding, and Poole was presented visually and rejected by both victims. Cotton had served 11 years when the defense, in spring 1995, finally obtained all preserved physical evidence for DNA testing. The sample from Thompson's rape kit had degraded beyond use. The sample from Watson's kit had not. The results excluded Ronald Cotton completely and identified Bobby Poole. Detective Mike Golden confronted Poole, who confessed to both rapes. On July 11th, 1995, Poole pleaded guilty and received a 70-year sentence added to the life term he was already serving for other sexual assaults. On June 30th, 1995, Ronald Cotton was officially cleared of all charges. On July 12th, North Carolina Governor James B. Hunt Jr. issued a full pardon. Cotton received $110,000 from the state. He was the first person in North Carolina's history to be exonerated through DNA evidence. The pattern in Thompson's case, a photo array administered by an officer who knew which photo was the suspect, followed by enthusiastic confirmation, followed by repeated re-identifications that each made the memory stronger and more wrong, is now taught in law schools and police training academies as a demonstration of every procedural failure, active simultaneously in a single case. The science of eyewitness memory had not yet produced the reforms that might have prevented the first arrest. Blind administration, sequential rather than simultaneous presentation, no post-identification feedback from investigators. None of those practices were standard in Burlington, North Carolina, in the summer of 1984. None were required by law anywhere in the country. Cotton married, had a daughter, bought land, and went to work at LabCorp, the company whose laboratory had run the tests that freed him. He and Jennifer Thompson Canino met face-to-face after his exoneration. They became close friends. They co-authored a New York Times bestseller, Picking Cotton, published in 2010, and have traveled together ever since to advocate for double-blind lineup procedures, built on the understanding that victim confidence and victim accuracy are not the same thing, and that the applause of investigators is among the most dangerous sounds in a police station. The most disturbing element of this case is not that a good faith victim made an error. It is that every institutional step that followed made that error permanent. 10.5 years lost. Case 03. Archie Williams, December 9th, 1982. The 100 Oaks neighborhood of Baton Rouge, Louisiana. After the perpetrator fled AE's home, forensic investigators moved through the house and lifted latent fingerprints from multiple surfaces. 9 of them, high quality, suitable for database comparison, found on the bedroom door and walls. The prints belonged to the man who had committed the crime. Investigators compared them to Archie Williams. They did not match. That finding was documented and effectively set aside. Over the next 36 years, the state of Louisiana would fight every systematic effort to run those 9 prints against a database that might identify whose they actually were. When that search was finally conducted in 2019, it returned a result in a single day. Archie Williams was approximately 22 years old and working as a manual laborer in North Baton Rouge when police received a confidential informant tip naming him as a suspect. He had no violent criminal history. His mother and sister testified at trial that he had been asleep on the couch of their apartment at the time of the attack. The case against him rested entirely on an identification that had already failed twice before producing a positive result, and on fingerprint evidence that definitively excluded him. Evidence the state then spent decades refusing to run against a searchable database. The assault had occurred in the middle of the afternoon. A man knocked on AE's door and handed her a promotional flyer. When she opened the door fully, he forced his way inside, produced a knife from a briefcase, and took her upstairs. A friend arrived and called out for AE. The perpetrator covered her mouth and stabbed her twice. A knock from a postal worker caused him to dress and flee. AE survived and provided investigators with a description, assisting with a composite sketch. Nearly a month after the attack, police showed her a photo array containing Williams. She did not select him. A second array was administered. She did not select him. Only after a live lineup, assembled on the basis of the confidential informant tip, did she identify Williams with a stated certainty of 70%. At trial in April 1983 in East Baton Rouge Parish, the unmatched fingerprints required an explanation. The prosecution provided one. The prints might belong to a carpet cleaner. No carpet cleaner was ever identified, named, located, or investigated. 9 prints from the bedroom walls of a violent crime scene were attributed to a hypothetical tradesman and dismissed. Williams' mother and sister testified to his alibi. 11 of 12 jurors voted to convict. The judge sentenced Williams to life without parole, plus 20 years at hard labor at Angola Penitentiary. The Innocence Project accepted Williams' case in 1995. For the next 2 decades, prosecutors refused consent for DNA testing and blocked submission of the fingerprints to a searchable database. A court eventually ordered limited DNA testing. Results excluded Williams, but identified only the victim's husband, leaving the perpetrator's identity unresolved. Williams' first formal request to run the crime scene prints through a database was filed in 1999. It was refused. The legal fight continued across years of motions, denials, and appeals. According to a subsequent federal civil rights lawsuit filed by Williams, a Louisiana State Police crime lab forensic scientist had deliberately created a misleading and scientifically inaccurate report on the rape kit evidence. The obstruction was not administrative error. In 2014, the FBI's National Fingerprint Database was replaced by NGI, Next Generation Identification, a significantly more powerful system. In March 2019, Commissioner Kinesiumke Kimball of the 19th Judicial District Court finally ordered the 9 prints submitted for comparison. On March 14, 2019, experts at Ron Smith and Associates and the Louisiana State Police Crime Lab ran the search. It returned Stephen Forbes. Forbes had been arrested in June 1986 while committing an attempted rape less than 2 miles from AE's home. 3 years after Williams had been sent to Angola for the crime Forbes had committed. Under arrest in 1986, Forbes gave taped confessions to 4 additional rapes in the same Baton Rouge neighborhood. He died in prison in 1996, meaning he could never face prosecution for the 1982 attack. On March 21, 2019, Commissioner Kimball vacated Williams' conviction. District Attorney Hiller Moore III addressed Williams directly at the hearing. "You are factually innocent, wrongfully convicted, and on behalf of the state, we apologize that you have suffered this." Williams walked out of the 19th Judicial District Courthouse in Baton Rouge. Later that year, he performed at Amateur Night at the Apollo. In 2020, he filed a federal civil rights lawsuit against the officials who had obstructed the fingerprint testing for 2 decades, 9 fingerprints, documented in 1982. Not matching the convicted man, sitting in an evidence file for 36 years, while prosecutors fought every request to run them against the database that eventually identified the true perpetrator in a single day. Stephen Forbes committed at least 5 additional sexual assaults in the same Baton Rouge neighborhood, while Archie Williams served the sentence for the one Forbes had committed first. None of those victims received any accountability either. Forbes died in prison in 1996 for unrelated offenses, and the 1982 attack on A.E.T.R. could never be prosecuted once his identity was confirmed. The carpet cleaner the prosecution described at trial was never located because there was no carpet cleaner. The 9 prints belonged to Forbes, and they had been saying so since the day they were lifted. 36 years of imprisonment, 1 day of database work. The disproportion is not an oversight. It is the architecture of the system's resistance. 36 years lost. Case 04. Cornelius Dupree, Jr. At some point in his 3 decades of incarceration, and then again at a parole board appearance, and then again at another, Cornelius Dupree, Jr. was offered the same proposition. Admit guilt for the 1979 rape and robbery for which he had been convicted, and the Texas prison system would consider releasing him. He refused. Every time the offer was made, he refused it. The state had built the formal mechanism for early release around a confession he would not give, because the confession would have been a lie. Dupree chose to continue serving a 75-year sentence rather than say something false. The DNA results that came back barely a week after he was finally paroled confirmed what he had been saying since the night of his arrest. Dupree was 19 years old and living with his mother in Dallas when police stopped him and his friend Anthony Massengill in December 1979, weeks after a woman had been assaulted in a liquor store parking lot on the city's south side. The perpetrator had forced his way into the victim's car, ordered her male companion out, driven her to an isolated location, and sexually assaulted her. Police were looking for a black male matching a general description. Dupree matched it. He and Massengill were identified by the white victim from a suggestive photo array. No weapon was ever recovered. No forensic evidence connecting Dupree to the crime was ever collected. The identification was the entirety of the prosecution's case. The victim was 26 years old and had survived the assault. Prosecutors pursued the robbery charge rather than the rape charge at trial. A tactical choice based on the judgment that aggravated robbery with a deadly weapon would produce the same prison time without requiring them to navigate the more complicated burden of the sexual assault evidence. On April 3, 1980, in Dallas County, Cornelius Dupree, Jr. was convicted of aggravated robbery with a deadly weapon. He was 20 years old. The sentence was 75 years. Multiple appeals followed across 2 decades. All were denied. In the early 1990s, after learning about the Innocence Project from a fellow inmate, Dupree wrote to the organization from prison. He understood the structure of his case, DNA testing that could exclude him, as the source of biological evidence from the assault would undermine the robbery conviction with it. The Innocence Project eventually filed a motion with Dallas County District Attorney Craig Watkins, who had established a conviction integrity unit specifically to review cases where biological evidence existed and might contradict a conviction. In 2010, evidence from the original 1979 case was located in county cold storage. DNA testing was authorized and conducted. In July 2010, Dupree was released on mandatory parole supervision after 30 years served. He lived under house arrest until October. DNA results arrived approximately 1 week after his release. He was completely and definitively excluded as the source of the biological evidence from the assault. On January 4, 2011, State District Judge Don Adams declared Dupree innocent in a Dallas County courtroom. You're free to go. Dupree was 51 years old. He had served more time in a Texas prison than any other DNA exoneree in the state's history. Dallas County's crime lab had maintained biological evidence in cold storage for 3 decades, an institutional practice rather than a legal requirement, and that practice was what made Dupree's exoneration structurally possible. Without it, the evidence would have been destroyed years before the Conviction Integrity Unit was created to look for it. Dallas County had produced 21 DNA exonerations in a decade. Dupree was the 21st. Nationally, at that time, only James Bain of Florida and Lawrence McKinney of Tennessee had spent more years wrongfully imprisoned among those eventually cleared by DNA evidence. Dupree's case and the 20 that preceded it in Dallas County reflected an eyewitness identification crisis concentrated in a single jurisdiction. Cross-racial identifications, suggestive procedures, single witness prosecutions, no physical corroboration. A pattern that the Conviction Integrity Unit was specifically designed to surface, and that the cold storage policy made actionable in a way that evidence destruction would have permanently foreclosed. The broader picture in Dallas County by 2011 was one of systematic failure concentrated in a single jurisdiction. The Conviction Integrity Unit that freed Dupree had been examining cases going back decades, cases where witnesses had misidentified defendants, where police had used suggestive procedures, where juries had convicted on single eyewitness testimony with no corroborating evidence. Dupree's case fit that pattern precisely. 1 victim, 1 identification, no physical evidence, 75 years. The county's willingness to investigate its own record did not make the convictions less catastrophic. It only made the accounting more honest. Under Texas compensation law, the most generous in the nation at the time, Dupree was eligible for $80,000 for each year wrongfully imprisoned, plus a lifetime annuity for a potential total exceeding $2.4 million. He married. He became a founding member of the Innocence Project's Exoneree Advisory Council and a prominent speaker on eyewitness identification reform. He has said publicly that his guiding principle throughout the parole board years was simple. Whatever your truth is, you have to stick with it. Dupree refused to purchase his freedom with a false admission year after year before one parole board after another. The DNA results confirming his innocence came back 1 week after he was finally released by other means. The truth had been sitting in a Dallas County storage facility the entire time. Of all the facts in this case, that timing is the most precise indictment. 1 week separated the parole board's repeated demands from the laboratory result that answered them. He had the right answer. The system required the wrong one. 30 years. Lost. Case 05, Marvin Anderson. In the summer of 1982, investigators in Hanover County, Virginia, needed to build a photo array for a rape case. They obtained a color identification card photo from Marvin Anderson's employer and placed it among 5 black and white photographs of other men. Anderson's face was the only one in color, there was no documented justification for this construction. The victim's eyes moved through the array and settled on the anomaly. She selected Anderson. 11 days later, she selected him again from a physical lineup. Nobody asked why his photograph was the only one in color. That question took 20 years, an imprisoned man's persistent appeals, and a DNA database to answer. Anderson was 18 years old in 1982, living just outside Richmond, Virginia, with his mother and sister. He had no criminal record of any kind. His dream since age 10, when he moved in next door to a fire station in Hanover County, had been to become a firefighter. Police identified him as a suspect through a single observation. The perpetrator had told the victim during the assault that he had a white girl. Anderson was the only black man in the area police knew to be living with a white woman. That observation, not a description, not a witness account, not any public tip, was the entire basis for his inclusion in the array. The assault had occurred in July 1982. A young white woman was beaten, threatened, and raped by a man who approached her on a bicycle in Hanover County. The bicycle had been stolen from its owner approximately 30 minutes before the crime. The owner saw John Otis Lincoln steal it. Community members already suspected Lincoln. Anderson had a documented alibi and witnesses who could confirm it, and he begged his attorney to call the bike owner and Lincoln to the stand. His attorney refused. That attorney was simultaneously representing John Otis Lincoln. He disclosed this to no one. He called no witnesses who might have directed suspicion toward Lincoln, and put nothing before the all-white jury that might have introduced reasonable doubt. The jury convicted Anderson on all counts: 2 counts of rape, forcible sodomy, abduction, and robbery. He was 18 years old with no prior record. The sentence was 210 years. 6 years into that sentence, in 1988, Lincoln appeared in court and confessed under oath to the crime for which Anderson was serving time. The judge declared Lincoln a liar and refused to reconsider the conviction. Anderson was returned to his cell to continue serving 210 years for a crime whose true perpetrator had just admitted to committing it. He served 15 years before being released on parole in 1997, still classified as a registered sex offender, still subject to all the restrictions that classification carried in Virginia. The Innocence Project accepted his case in 1994. The rape kit, believed destroyed, was eventually located by investigators. Virginia passed a post-conviction DNA testing law in 2001, a law that had not existed when Anderson first sought testing. The results excluded Anderson and implicated Lincoln. On August 21, 2002, Marvin Lamont Anderson became the 99th person in the United States exonerated through post-conviction DNA testing. Governor Mark Warner issued an absolute pardon. I am convinced that Mr. Anderson is innocent of the charges for which he was convicted. Anderson received $1.2 million in compensation and had his record expunged. Virginia's resistance to post-conviction DNA testing access was not unique to Anderson's case. The state had not passed a testing statute when Anderson first sought access in the early 1990s, placing him in a legal gap that other states had already begun closing. His attorneys had to fight for access on ad hoc terms while the evidence sat in a state facility. The DNA testing law Virginia passed in 2001 was partly a product of advocacy driven by cases like his. Where the evidence existed, the question was answerable, and the system provided no pathway to answer it. Anderson later became a national voice in pushing for those reforms, serving on the Innocence Project's board of directors and speaking publicly about the color photograph, the conflicted attorney, and the judge who dismissed Lincoln's confession. The procedural failures stacked in Anderson's case, a structurally biased array, a dual representation conflict, a judge who disbelieved a sworn confession, a state with no post-conviction testing statute, were individually correctable and collectively lethal. Removing any single one of them would have changed everything. None were removed. Instead, they accumulated. The attorney who represented Anderson at trial also represented John Otis Lincoln. He watched Lincoln confess in open court 6 years into Anderson's sentence and did nothing. He called no witnesses at trial who might have directed suspicion toward Lincoln. He concealed the conflict of interest from Anderson, from the court, and from the bar. He was disbarred in 1999, not for his conduct in Anderson's case, but for separate misconduct violations. He was never sanctioned for the conflict of interest that had placed his two clients on opposite sides of the same crime. Anderson became chief of the Hanover County Fire Department, the career taken from him at 18. He oversees a team of 30 people and has spoken at fire stations across Virginia about what the justice system did to him and what forensic science ultimately corrected. The most disturbing fact is not the color photograph, though it is indefensible. It is not the conflicted attorney, though he should have been prosecuted rather than merely disbarred for different misconduct a decade later. It is the judge who watched John Otis Lincoln confess in open court and decided the confession was a lie. That decision extended the sentence by 13 more years. 15 years. Lost. Case 0. 6. Jerry Miller, September 1981. Downtown Chicago. Police detained Jerry Miller in the vicinity of a parking garage where a violent assault had occurred and placed him in the back of a squad car. They drove the car to 2 parking garage attendants who had witnessed the attack and asked them a direct question. Is this him? There was no formal lineup. There were no alternative photographs. There was no procedural buffer between the police's implicit assumption and the witness's answer. There was a man in a police vehicle and a yes or no question posed in the immediate aftermath of a traumatic event. The attendants said yes. That answer, obtained through a procedure called a show-up, condemned by researchers as the most inherently suggestive identification method available to law enforcement, sent Jerry Miller to prison for 24 years. Miller was 22 years old at the time of the assault, a military veteran with more than 3 years of service, and a man with no history of violent crime. A police officer had seen the composite sketch assembled from the victims' and attendants' descriptions and decided it resembled Miller, someone the officer said he had noticed near the garage in the days before the attack. That resemblance and that officer's recollection was what placed Miller in the back of the squad car. The victim herself, the 44-year-old office worker who had been beaten, robbed, raped, and locked in the trunk of her own car, told investigators she was unable to identify her attacker. She could not make an identification. The conviction that followed rested entirely on 2 bystander attendants and the show-up that produced their confirmation. The assault had occurred on the night of September 16, 1981, just after 9:30, on the roof deck of a downtown Chicago parking garage. A woman was approaching her car when a man pushed her into the vehicle, beat her, robbed her, and raped her. He forced her into the trunk and tried to drive the car out of the garage. The cashier recognized the victim's car. Employees closed in, and the perpetrator fled on foot. They freed the woman from the trunk. She was hospitalized. The true perpetrator was Robert Weeks, later imprisoned for other sexual assaults. When his DNA profile was entered into the FBI database, it matched the evidence from Miller's case. By then, the statute of limitations on the 1981 assault had expired. Weeks could not be charged. The show-up procedure that produced Miller's identification has been the subject of sustained criticism from legal scholars and eyewitness researchers for decades. Unlike a properly administered photo array, which presents multiple individuals with the administrator blind to who the suspect is, A show-up presents a single individual in circumstances that implicitly communicate that police believe this is their man. Witnesses at show-ups are not choosing from options. They are being asked to confirm or deny a decision law enforcement has already made. Research consistently shows higher false positive rates from show-ups than from sequential or blind array procedures. The contamination is immediate and irreversible. Once a witness has confirmed an identity at a show-up, that confirmation becomes the foundation of every subsequent identification they make, including at trial. The Cook County courts that convicted Miller in 1982 were under no obligation to instruct the jury about any of this. They did not. No Illinois statute required them to. The show-up produced its confirmation in a parking lot, and the legal system treated that confirmation as though it were recognition. Before Miller's trial, the city of Chicago presented citizens' awards to the two parking attendants for their role in identifying the suspect. Awards given before any verdict was rendered. On October 1st, 1982, a Cook County jury convicted Miller of rape, robbery, and aggravated kidnapping. He was sentenced to 45 years for rape and kidnapping, and an additional 7 years for robbery. Before sentencing, Miller told the judge, "Your Honor, I understand that I stand accused and I've been found guilty by the state of Illinois. But sir, I am not guilty." Miller served 24 years before being paroled in March 2006. The parole came with conditions: a required electronic monitoring device at all times, sex offender registration, restrictions on answering his front door on Halloween, and limitations on leaving his workplace during the day. The Innocence Project accepted his case in 2005. Attorneys located a semen sample preserved on a piece of the victim's clothing at the Cook County Clerk's office. DNA testing at Strand Analytical Laboratory excluded Miller. The profile matched Robert Weeks in the FBI database. On April 23, 2007, the Cook County State's Attorney's Office, the Innocence Project, and the Cook County Public Defender filed a joint motion to vacate. The conviction was dismissed. Governor Rod Blagojevich granted a pardon based on innocence. Jerry Miller became the 200th person in the United States to be exonerated through DNA evidence. The Innocence Project launched its national 200 Exonerated, Too Many Wrongfully Convicted campaign the same day. In 2010, the city of Chicago settled a civil rights lawsuit on Miller's behalf for $6.3 million. The city gave civic awards to the men whose show-up identification sent Miller to prison. It paid $6.3 million, 29 years later, to acknowledge what that award had cost. The victim, the only person who had actually seen her attacker, told investigators she could not make an identification. The system convicted Jerry Miller anyway, on the basis of two bystanders who had confirmed a name they were given by police. Rather than recognizing a face they had independently registered. Robert Weeks, the man who actually committed the crime, was never charged. The statute of limitations had run. He lived out his life never prosecuted for the assault that cost Miller 24 years. 24 years lost. Case 07. Kevin Strickland. For approximately 30 years, a woman named Cynthia Douglas tried to undo what she had done. She wrote letters to politicians, lawyers, judges, and anyone she believed might have the authority or mechanism to correct the identification she had made in 1979. She had been the only survivor of a triple murder in Kansas City, Missouri. Shot in the arm during an attack that killed 3 people. And under pressure from police and a friend, she had named Kevin Strickland as one of the gunmen. She had been wrong. She knew it for decades. She died in 2015 without seeing him freed. Strickland was released 6 years later on November 23, 2021, at the age of 62, having served 43 years, the longest wrongful imprisonment in Missouri history. and among the longest in the country. Strickland was 18 years old when the murders occurred on April 25, 1978. He told police from the moment of his arrest the following day. He had been home watching television. There was no physical evidence connecting him to the scene. His first trial ended in a mistrial. His second, in 1979, proceeded before an all-white jury. The conviction rested on a single witness, a traumatized woman who had been shot, who was under pressure from multiple directions, and who identified a young man she recognized from the neighborhood. Rather than a stranger she had carefully observed committing a crime. That distinction between recognition under pressure and reliable eyewitness identification would not find its way into the legal proceedings for more than 40 years. The victims were Sherry Black, 22 years old, Larry Ingram, 21, and John Walker, 20. 4 gunmen entered a Kansas City home, restrained the occupants, and shot them. All 3 died. Cynthia Douglas, the sole survivor, was shot in the arm. Traumatized and under pressure from both police and a friend who knew Strickland from the neighborhood, she identified him as one of the 4 men involved. The true perpetrators included Vincent Bell and Kilm Adkins, both of whom later pleaded guilty to the murders. Years afterward, both provided sworn affidavits stating unequivocally that Strickland had not been present. Both named the 2 other individuals who had actually participated alongside them. None of this was before the 1979 jury. On June 29, 1979, Kevin Strickland was convicted of first-degree murder and 2 counts of second-degree murder. The sentence was life in prison with the possibility of parole after 50 years. He entered the Missouri prison system with no physical evidence against him, an alibi he had maintained since his arrest, and the testimony of a single witness who, within years of the conviction, had begun writing letters saying she had been wrong. Douglas spent 3 decades attempting to correct her identification through every channel available to her. She contacted advocacy organizations, elected officials, and legal authorities. She told family members, friends, and co-workers what she had done and why she believed Strickland was innocent. The legal system offered no mechanism by which a recanting eyewitness could reverse a conviction without additional corroborating evidence. Douglas had nothing to offer except her own account that she had identified the wrong man under pressure. She died in October 2015. Her family and friends testified about her statements at Strickland's evidentiary hearing, 6 years after her death. Missouri's refusal to compensate Strickland after his exoneration exposed a structural gap in the state's wrongful conviction framework that advocates had flagged for years. Missouri's compensation statute tied payments to a specific DNA testing pathway. Strickland's exoneration came through a prosecutorial petition and recanted testimony, legally sufficient to vacate the conviction, but insufficient under Missouri law to unlock any compensation. He left prison at 62 in a wheelchair, and the state paid him nothing. No annuity, no lump sum, no acknowledgement in financial terms that 43 years had been taken from him. Texas, by comparison, had passed the country's most generous wrongful conviction compensation law following its own wave of exonerations. Missouri had not. The gap between what different states owed exonerees and what they were willing to pay was, in Strickland's case, the full distance between a life and nothing. Advocacy groups called for Missouri to pass a broader compensation statute in the aftermath of Strickland's release. The legislature did not act. He remained uncompensated as of the time of his exoneration and beyond, one of the longest-serving and least acknowledged wrongful imprisonment victims in American legal history. Missouri's legislature had passed a law enabling local prosecutors to petition for the release of prisoners they believed to be innocent. Jackson County prosecutor Gene Peters Baker launched a formal reinvestigation and concluded the evidence of Strickland's innocence was clear and convincing. Attorney General Eric Schmidt publicly opposed the effort. Governor Parson declined clemency. A 3-day evidentiary hearing convened in November through 2021. Retired Judge James Welsh reviewed the record and ordered immediate release on November 23rd. Strickland was convicted solely on the eyewitness testimony of Douglas, who subsequently recanted. Cynthia Douglas spent 30 years trying to free the man she had wrongly identified. She died before the legal system found any will to listen. 6 years after her death, a court heard what she had been saying since the early 1980s and acted on it. The structure of her failure is as important as its outcome. She was a private individual with no legal standing, no financial resources, and no mechanism to compel review of a conviction she had produced. She was the state's only witness, and she was recanting, and the state had no pathway for that. Strickland remained incarcerated for every year of her attempt and for 6 years beyond her death. 43 years lost. Case 08, Malcolm Alexander. November 5th, 1980. Jefferson Parish, Louisiana. Jury selection began in the morning. By 5:20 in the afternoon, the prosecution had presented its witnesses. The defense had concluded, and both sides had delivered closing arguments. At 6:16 that same evening, 56 minutes after deliberations began, the jury returned. Guilty. The judge sentenced Malcolm Alexander to life in prison without the possibility of parole. The entire proceeding, from the selection of 12 jurors to the imposition of a mandatory life sentence, had occupied a single business day. Alexander was 21 years old. His son, Malcolm Stewart, was 2. Alexander had steady employment as a contractor's worker in the Gretna, Louisiana area, and no prior criminal record. On the morning of November 8, 1979, BN, a 39-year-old white woman who owned an antique store at 363 Whitney Avenue in Gretna, was alone in her shop when a black man rode up on a 10-speed bicycle, entered, and asked the price of a coffee table. He then raped her repeatedly on the floor. She survived. She described her attacker as approximately 6 feet tall and assisted with a composite sketch. When police showed her a photo array, her selection of Alexander was, by every account in the investigative record, tentative and uncertain. She was not confident. She expressed hesitation. The documented reality of the identification was a qualified, ambiguous choice. When the lead detective took the stand at Alexander's trial, he told the jury something different. He testified that BN had selected Alexander without a single shred of hesitation. That was a lie. It directly contradicted his own investigative notes. It directly contradicted the documented reality of the identification procedure. That lie, delivered under oath in a courtroom where the defense attorney would not challenge it, was the decisive act of a one-day trial. The defense attorney was Robert Tosh. He made no opening statement. He called no witnesses. He did not challenge the identification procedure, did not present evidence of Alexander's alibi, and did not meaningfully cross-examine the state's witnesses. His closing argument filled 4 pages of an 87-page trial transcript. He promised to file an appeal. He never did. Tosh was disbarred in 1999 for 60 documented misconduct violations across dozens of cases, including stealing client funds and abandoning clients with active serious criminal exposure. He was never specifically sanctioned in connection with Alexander's case, a case in which his failures had been especially consequential, collapsing what should have been a contested proceeding into a formality that concluded before dinner. The one-day trial was not a product of a clean, well-documented case. It was a product of an attorney who did not try. 3 pubic hairs had been recovered from the floor of BN's antique store at the time of the original investigation, left by the man who had committed the crime. The rape kit and a semen-stained towel were destroyed 4 years after Alexander's conviction. The pubic hairs were not. They sat in a file at the Jefferson Parish Sheriff's Office crime lab for over 3 decades. In 2013, investigators located them. DNA testing confirmed that all 3 hairs came from the same individual. That individual was not Malcolm Alexander. Alexander had contacted the Innocence Project in 1996 after reading a news article about DNA exonerations. The organization accepted his case, discovered the rape kit had been destroyed, and spent years pursuing any remaining biological evidence. When the hairs were found in 2013, the legal route to exoneration became viable. In 2017, Innocence Project attorneys Barry Scheck and Vanessa Potkin, joined by Innocence Project New Orleans, filed a motion to vacate, citing both the DNA evidence and the catastrophic failure of Tosh's representation. Jefferson Parish Judge June Barry Derensburg dismissed the indictment on January 30th, 2018. The compensation Alexander eventually received, $480,000, after a 5-year legal battle following his exoneration, required a separate civil proceeding. Louisiana's compensation statute was not automatically triggered by the vacatur of his conviction. His attorneys had to establish eligibility through additional litigation, and the state initially contested the claim. An appellate court reversed the trial court's denial and remanded with instructions to calculate the award. 5 more years of legal proceedings after 38 years in prison. That additional fight was not unusual. It was the standard structure of Louisiana's wrongful conviction compensation framework, appended to a life sentence imposed on the basis of a detective's lie. Alexander was 59 years old when the Jefferson Parish courts finally finished with him. He had entered the Louisiana prison system as a 21-year-old father and emerged as a grandfather. Robert Tosh, whose 4-page closing argument and broken promise to appeal had sealed the one-day verdict, had been dead for years by the time the DNA results came back. He was never held accountable for what he had done to Malcolm Alexander. Alexander was released from Angola on January 30th, 2018. His son, Malcolm Stewart, then 40 years old, was waiting outside. So was his grandson, Malcolm III, who at approximately 20 was nearly the same age his grandfather had been at conviction. 3 generations of a family, shaped by a detective's lie. The lie was 4 words, without a single shred of hesitation. The detective said them in a courtroom in less than 10 seconds. The trial lasted 1 day. The sentence lasted 38 years. The 3 hairs that disproved the lie had been sitting in an evidence file at the Jefferson Parish Sheriff's Office crime lab since 1979, in a building less than a mile from where Alexander had been convicted. The hairs were there the whole time. The truth was there. The system simply never looked. 38 years lost.